welcome to the 251st episode of The Firm. On the show this week, why US Judge Barbara Jones does not think Satyam's independent directors were recklessly negligent, and why Sahara has not abided by 2 Supreme Court orders and yet no one's doing anything. Were Satyam's independent directors recklessly negligent in not detecting the $1 billion fraud perpetrated by Ramalinga Raju? US Judge Barbara Jones says no. This was the outcome of a class action suit filed by some investors and an employee against the independent directors as audit committee members. Now, Judge Jones' decision limits US jurisdiction and limits independent director liabilities. I spoke to Irvin Warren, the lawyer who represented the directors, and Ernest Bagway, a former SEC attorney, to better understand the highlights of this decision. 4 years ago, on January 7, 2009, Ramalinga Raju, the chairman of India's 4th largest IT company, Satyam, confessed to having overstated the company's assets by over $1 billion. The fraud included fabricated interest income, overstated receivables, hidden debt, forged bank documents, fake invoices, and fictitious employees. In 2009, a consolidated class action was filed against Satyam, some of its officers, outside directors, outside auditors, and other entities in the U.S. District Court for the Southern District of New York. The allegations against the independent directors, also audit committee members, were that they recklessly disregarded their responsibilities in the face of extensive information that should have caused them to discover and prevent the fraud. The independent or outside directors, as they're referred to in the US, filed for dismissal of the class action claims on grounds of lack of jurisdiction and the lack of merit. And last week, they succeeded. To begin with, Judge Barbara Jones threw out certain claims on grounds of lack of jurisdiction, and in doing so, she applied the 2010 US Supreme Court decision in the Morrison case.
You know, it's a very interesting decision because over the last several years, the American courts have retrenched from their belief that American courts can have jurisdiction over disputes that take place across the globe. And what the Morrison case held was that unless the transaction occurred in the United States, it occurred, or the conduct occurred in the United States, it was not going to be allowed, the dispute would not be allowed to be brought in American courts. So in many respects, the Morrison decision was viewed, at least globally, as an acknowledgement that American jurisdiction ends at our shores. And what Judge Jones did was applied that decision. As you're aware, there were 3 types of securities involved. Securities that were traded on the New York Stock Exchange, securities that were traded on the National Exchange in India and also the Bombay Stock Exchange, and then stock options. And what Judge Jones did was dismiss the claims relating to those shares that were traded on the Indian exchanges and also the stock options as not occurring in the United States. The Morrison decision is applicable to private litigation. It is still unclear whether the Morrison case will apply to SEC, Securities and Exchange Commission, enforcement actions. The Commission has taken the position that they can still follow, I suppose the lead is the best way of putting it, and look at activities occurring overseas as affecting the United States.
The class action sought to establish a securities claim under the Exchange Act on the grounds that the independent directors, as audit committee members, recklessly allowed the Satyam fraud to go undetected. But Judge Jones ruled that the plaintiffs failed to establish either that the directors had any motive or intent to allow a fraud to go on, or that the directors ignored any red flags that supposedly should have alerted them to a fraud. Red flags such as the exorbitant fees allegedly paid to outside auditor PwC. The plaintiffs alleged the directors did not investigate these fees sufficiently. Judge Jones ruled that would have amounted to negligence at the most, not reckless negligence. The directors were also accused of not taking adequate steps to investigate internal financial reporting deficiencies. Judge Jones ruled that no facts were offered as to how a more thorough investigation would have led to the discovery of the fraud. The class action also alleged that the directors had rubber-stamped the Maytas transaction decision without inquiring about the justifications for it, despite the fact that it reflected an irrational business decision and would have benefited the Raju family directly. But Judge Jones found nothing remiss in the board's approval of the Maytas merger with Satya.
Number one, she said the directors asked the right questions. Number two, she said they got reasonable answers, and directors are entitled to rely on management. But most important, and you tell me, maybe you've seen it, but I sure haven't, the fact of the matter here is the directors, in voting on this transaction, specifically said that they wanted additional independent valuations on this transaction and expressly conditioned their preliminary approval on getting those valuations, on being satisfied by them, and indeed expressly reserved the right to revoke any approval if they weren't satisfied with those valuations. Now that's exactly the kind of further information and second look that frankly I would think people would applaud a board for doing.
I've been personally involved in cases where a board of directors has made a decision in less than a half a day, and that decision has been upheld with all types of legal scrutiny. And then I've been involved in other cases where the board of directors had taken months upon months, and in one case over a year, to come to a decision. They were sued, and they were ultimately found liable. So it's difficult to look at it just from the perspective of just looking at it for one day and making a decision. And you have to look at the business judgment that was involved and how they made this decision. And that's what Judge Jones did. The courts cannot replace their judgment with the business judgment of the board of directors of any company.
Judge Jones ruled that the majority of the allegations in the class action complaint concern an intricate and well-concealed fraud perpetrated by a very small group of insiders, and only reinforced the inference that the AC defendants, that is the independent directors or the audit committee members, were themselves victims of the fraud.
Most obviously, this was a situation where a handful of insiders had a carefully crafted, executed, and carefully concealed fraud that, as Ramalinga Raju's confession letter said, the directors didn't know about. Second, the company had a Big Four audit firm, Price Waterhouse, as their independent outside auditors, and there's no question that the auditors, neither outside auditors nor internal audit, had alerted the directors, whether on the audit committee or otherwise, to any kind of wrongdoing, and the court found there were not so-called red flags that the directors knew of, much less ignored. And if you take the totality of that, I think the conclusion of the directors as victims of this is inescapable.
Judge Jones's decision is certainly not out of the ordinary. It is in a long line of cases that have held the same way. I believe, and I'm only purely speculating now, that if Judge Jones had presented with allegations from the plaintiffs that the outside directors were aware that the memos, that the invoices had been fraudulent, or that they had gotten some indication from, say, a whistleblower that the invoices and the contracts had been inflated and that the company had been hiding these issues, then the outside and independent directors would have been less likely to have succeeded in this particular case.
And so, Judge Jones has cleared Satyam's independent directors of any reckless negligence that could have contributed to the fraud. I suppose that's good news, not just for them, but for all independent directors.
This is a decision that recognizes that you don't blame, much less impose liability on, your directors when there's a management fraud to begin with, and where the outside auditors don't alert you to the fraud. I think if the judge had come out any other way, somebody would have to think long and hard before being willing to be a director, because you'd almost be at the point of saying the directors are the guarantors or they're the insurers. And they're not. They're directors.
They still have an absolute obligation to the company to make sure that what the business that the company is engaging in is appropriate, legal, and meets all standards regardless of the jurisdiction in which they are in. Essentially, they cannot stick their head in the sand. They have to pay attention to what's going on, they have to inquire, and they have to make sure they make appropriate business decisions.
Now, this analysis would be incomplete if we didn't get you an Indian legal perspective. And so I spoke to Pallavi Shroff of Amarchand Mangaldas. Pallavi had aided in the quick government takeover of Satyam and its subsequent sale to the Mahindra Group. She says it's a good judgment that applies a high standard of proof and that India would do the same even after the new companies bill becomes law.
If you do all the right questioning, the right answering, you can make yourself familiar with the company, but ultimately, don't forget you attend these 4 board meetings in a year. So how much more can you ask? You can defer issues, you can ask questions, but that's about it that you can do. So keeping that focus in mind, I think this is a good judgment. I think what is important is she has not gone by the sentiment or perception, she's gone by the actual standard of proof that is required in proving such cases. And let me tell you, the standard of proof that she states in her judgment is pretty much the standard of proof that we would have in India. If you look at the judgment and you look at the new companies bill and the liability of directors, there's not that much of a difference. If you had knowledge, of course you have to be held liable, but it does not mean that you have to go and discover frauds like an investigative officer or do a forensic investigation right there.
While Satyam's independent directors are home free, at least in the US. So far in that country, Satyam has paid $125 million to settle one class action. PwC has paid $25.5 million to settle another. PwC has also paid SEC and PCAOB a $7.5 million penalty. All this while India has done nothing. Take a break. On the other side, we go from Satyam to Sahara. Why Sahara has not abided by 2 Supreme Court orders, and yet no one's doing anything.